Really excited to have this conversation today on the latest executive orders and how the orders might impact HR leaders, our teams, our organizations, given the rapid shifts we're seeing in key areas like DE&I, healthcare, and immigration. It's more important than ever for HR teams to stay informed and proactive. So today we're joined by legal experts from the Kutak Rock team to help us break down what these executive orders mean in practice, what's changing, what risks there might be, and opportunities to consider, and how we can best prepare for future legislation. By the end of this discussion, we hope you walk away with clarity on these updates, how they might affect your work, practical steps for adapting policies and programs, and expert insights to guide your HR strategy moving forward. And I want to acknowledge that a lot of the issues that we're talking about today might be polarizing. Our aim in this webinar is to really make sure that everyone is aware of the legislative changes and how it might impact your work. We ask everyone to keep comments in the chat focus on the facts, and as always, please be respectful of others. And I also want to acknowledge that dealing with these changes can be emotionally draining, and outside of this webinar, I'm happy to be a resource to folks. I'm really impressed with how the HR community leans on each other during times of change, and happy to be a resource outside of this webinar in addition to the content that we're going over today. So the structure today, we have a lot to cover. We'll start with quick intros and then dive into healthcare and benefits first, followed by DE&I, and then immigration. Please feel free to drop in questions in the chat as we go, or you can directly add them to the Q&A function. We'll save some time at the end to go over those questions, and looking forward to seeing those. And then I guess before we dive in, a quick introduction about myself. I'm Alana Maskov. I'm the Director of People and Talent Operations here at Nava Benefits. For those of you who aren't familiar, we're a benefits brokerage with the mission of providing high quality, affordable healthcare to all Americans. And that starts with providing innovative benefit strategies to clients, reducing administrative burden for HR, and improving the overall employee experience. And as the HR leader at NAVA, I'm in charge of understanding how this legislation might impact our workforce. So I'm looking forward to learning alongside all of you in this webinar, to navigate these uncharted waters together, and looking forward to learning from the Kutak Rock team. So with that, I'm excited to announce the Kutak Rock speakers, some of our trusted legal advisors at NAVA who bring deep legal expertise in these topics. We'll start with an intro from John and then pass it on to Casey and then Cleet.
Thanks, Alana. Hi, everybody. I'm John Shimbori. I head up the employee benefits and executive compensation team here at Kutak Rock. I've worked with Nava for a number of years, providing some behind-the-scenes employee benefits guidance and advice, and have done a couple of webinars, so I may have spoken to you previously. And I'm very excited to have two of my incredible partners here with me, and I'm going to introduce now Casey.
Thanks, John. My name, as John said, I'm Casey Capilano. I'm a partner in Kutak Rock's employment litigation group based in Omaha. I handle discrimination, harassment, and retaliation claims in state and federal agencies like the EEOC and the NLRB, as well as in state and federal courts. I also do a lot of advice and counseling on a day-to-day basis for employers. And I am a co-chair of our group's employee handbook team. So I do a lot of employee handbook work as well. Cleet?
Thank you, Casey. I'm Cleet Sampson. I'm an immigration partner also in our employment group. I have approximately 20 years of experience in immigration law, 9 of which were spent actually working for the Department of Homeland Security as a federal prosecutor. So excited to share my perspectives on some of the immigration impacts on HR departments across the country in light of some really never before seen enforcement, and looking forward to having that discussion with you all.
Thanks for the quick intro, team. Looking forward to learning from all of you in this session. With that, I will pass it back to John to kick us off on healthcare and benefits.
Great. Thanks, Alana. Well, my job is to keep this very short because Casey and Cleet have some really much more interesting stuff than I'm going to share. But I do want to talk a little bit about what the new administration's doing, that might impact benefits, particularly health benefits. So I'm going to talk about 4 different executive orders. These, as those of you have been reading in the papers, they don't necessarily have the same effect as a statute or a regulation, but it is certainly the administration's outlook and view on certain matters. So the first one that we had, the first executive order, is the Defending Women from Gender Ideology Extremism and Restoring Biological Truth to the Federal Government. As Alana said, it's hard not to get politically charged when you read some of these executive orders, but we're trying not to. And I think Casey's going to talk a little bit about this one as well. How this one impacts employee benefits. For those of you that practice in the benefits world know, since the Affordable Care Act was passed under the Obama administration, there was a section of the Affordable Care Act that required, for health plan purposes, required gender and gender identity to be treated the same as sex. And so if you had a health plan and you provided certain types of care only to the female sex and not to the male sex, that would be discrimination. And so what this provision of the Affordable Care Act did was extend that to gender. So if there were certain types of medical benefits that you provided to a certain gender, you had to provide it to all genders. Otherwise, it would be considered sex/gender/gender identity discrimination. As you might imagine, this was very political ever since it was enacted. And as we've gone through different administrations, the administrations have either tried to promote this or demote this requirement. So prior to the Trump administration, this provision of the law, which really applied to a lot of kind of gender transition, gender dysphoria type medical treatments, only applied to health plans that received federal funding. So the law was written very broadly. Everybody thought it was going to apply to all of our health plans. In reality, it is only extended to those plans that receive federal funding, which are very, very few health plans that receive federal funding. So in any event, this executive order by the Trump administration mandates that gender identity and sex be treated the same. So there is no ability to argue that a gender dysphoria type treatment is something that has to be provided under a health plan. Again, not much practical impact on us because we didn't have to deal with it before, but a significant change nonetheless. Similarly, the Protecting Children from Chemical and Surgical Mutilation executive order also focuses on the Affordable Care Act. And there was a push under prior administration to say that gender identity surgeries was an essential health benefit under the Affordable Care Act. Without getting into all the weeds, employers sponsoring group health plans, those health plans had to offer essential health care benefits for them to be considered qualified group health plans to avoid all kinds of penalties. And what this executive order says is that not providing gender identity surgeries and treatment is not going to impact a plan's status as providing essential health benefits. Some of you may have seen over the years certain states, legal aid societies challenging group health plan provisions that did not provide these types of services. Some of the arguments were a Title VII based argument. Some of them were a mental health parity type argument. Some of them were a Section 1557 of the Affordable Care Act argument. This argument goes away. Doesn't mean the other arguments still don't exist, but this argument goes away. So this just makes it a little bit less likely that a challenge on a plan that does not include gender identity surgeries or treatments is going to be considered discriminatory. Okay, so the next 2 executive orders that I'll mention. The third is this initial rescission of harmful executive orders and actions. Basically, this has kind of been I don't know, this has kind of been the norm, unfortunately, in the last couple of presidential changes in office, where the first thing the new administration does is pass an executive order that says, I want to get rid of everything that the last administration did. Well, that's what this order does. As it applies to health benefits, under the Biden administration and Obama's administration, not surprisingly, there had been attempts to significantly increase the scope of the marketplace, the healthcare exchanges. As going a little through history lessons, the way Obamacare came about was they really wanted a national healthcare system. That wasn't going to work. So we came up with Obamacare. Obamacare created the healthcare exchanges in every state and made those available. There's a requirement that employers provide a certain type of benefits. Otherwise, they have to pay a penalty. There was a thought when Obamacare came out that all of us in HR, we wouldn't have health plans and they would all go away. That didn't happen. But we still there's competition out there. These exchanges are out there. So under the Biden administration, there were attempts to make those marketplaces more attractive to consumers so that consumers didn't have to rely on their employer for health plans. They made them more attractive by increasing the subsidies that certain lower paid employees could get. So in essence, get free or significantly reduced healthcare coverage on an exchange, such that it didn't make sense for an individual to enroll in their employer's plan because it was far more cost effective to enroll on an exchange plan. There was also an increase push on access to exchange plans with an increase in funding for state Medicaid programs. And again, all this administrative executive order does, is Trump saying, I don't like what Biden did, and we're going to get rid of that, and we are not going to increase subsidies, and we're not going to increase funding to Medicaid to increase. It doesn't do anything about the exchanges. They are still there. It's just the intent of the government to not promote the exchanges to the detriment of the employer-based plans. And then the final executive order that I want to talk about is the Unleashing Prosperity Through Deregulation order. Not necessarily specific to health benefits, but it impacts health benefits a little bit. This executive order is that there will be no new proposed regulations by any agency without Trump signing off on it. There will be a withdrawal of any recently announced proposed regulations. And this could impact health plans because we have some proposed regulations under HIPAA with some new cybersecurity regulations and guidelines, and those were proposed. And now there's going to be the withdrawal of them, or at least the intent to withdraw those. It's not clear whether he can withdraw those or not, but the intent to withdraw those. And then the third part of this is that there is an encouragement of all agencies for those regulations that the Trump administration was too late on in stopping from going into effect, a strong encouragement from the administration to delay the effective date of those regulations until the Trump administration signs off on that. One here that applies to benefits is there's a new regulation that would help clarify what fair market value means for an employee stock ownership plan, an ESOP. It's a retirement plan that invests in the stock of the company. And there's lots of uncertainty around what does it mean to say the stock has to be valued at fair market value. And so we finally got regulations after years and years of begging for them. And now the Department of Labor is being encouraged to not implement those quite as quickly. Then the last item, I'll mention two other just tangential comments. First, the Trump administration's general approach to regulations under Trump 1.0, he didn't want to see a new regulation unless two other regulations were repealed. That was one of his attempts to streamline business operations, was to get rid of these regulations. Trump 2.0 is on steroids. And so the policy is he doesn't want to see a new regulation unless 10 old regulations are being withdrawn. So that's pretty significant. So we're not expecting to see, at least in the benefits world, we're not expecting to see a lot of new regulation because it's going to be pretty hard for agencies to say, all right, we can get rid of 10 other regulations. The only other item I'll mention, not an executive order, but just where things might be going. It will be important to pay attention to who ends up running the government agencies that oversee benefit plans. So earlier today, for example, an individual was nominated by Trump to head up the Employee Benefit Security Administration office within the Department of Labor. And the individual that was nominated to head it up had been he's a lawyer and a fiduciary liability insurance carrier. He's a very, very big practical proponent of more common sense rules for fiduciaries that run employee benefit plans. If he becomes ratified and heads up the Department of Labor, that will be a huge shift in enforcement activity. And I expect we will see some meaningful change, both in enforcement activity, but also in the form of certain types of guidance that could be very, very much more pro-employer, pro-fiduciary than we've seen in the past. So with that, I'm happy to take questions at the end, throw them in the chat box, but let's get to the good stuff, and I'll pass it on to you, Casey.
Thanks, John. I don't know if it's the good stuff, but it's some DEI stuff, that's for sure, quite a bit of it. So just for completeness, I am going to touch on the executive orders that relate to DEI, even that are not 100% pertinent to employers, because I think it gives you a sense of the thinking and where they're headed. So the very first executive order that I want to start with is the order entitled Ending Radical and Wasteful Government DEI Programs and Preferences. So as I just foreshadowed, this is aimed almost solely at the federal government, and basically requires termination of all DE policies and plans and preferences in the federal government to the fullest extent that they can be terminated. Notably, I think this is interesting, the order also requires a list of DEI offices and positions, plans, programs, or initiatives that were in existence on November 4th, 2024, and an assessment of whether they've been misleadingly relabeled in an attempt to preserve their function. So apparently we're going after substance here. All right, and so then I want to move to the next slide. We're going to, I'm going to briefly again just touch on this order, Defending Women from Gender Ideology, Extremism, and Restoring Biological Truth. As John mentioned, this order basically states the United States recognizes only two sexes, male and female, and these are based on cells present at conception. At least that's what it says. And the distinction here is that sex does not include gender identity, and gender identity is defined to be a fully internal and subjective sense of self and not a replacement for sex. So obviously that's got significant consequences for interpretation of Title VII and employment laws that we're going to talk about a little bit later in the presentation. So basically this requires federal agencies to use sex in all official policies and documents, and it also directs the Attorney General, Secretary of Labor, and the EEOC to prioritize investigations and litigation to enforce policies regarding two genders. So I'm expecting that to include issues or complaints related to allowing persons who identify as transgender to use the bathrooms that align with their identity, and potentially things like pronouns and objections to using same, things like that are kind of what I'm expecting out of this order. All right, so the next executive order is Ending Illegal Discrimination and Restoring Merit-Based Opportunity. This was issued on January 21. And the first substantive section of this order is pretty similar to the first one we talked about, and basically just tells the federal government to get rid of all DEI programs from with respect to the federal contracting process. And next, there are orders that directly impact federal contractors, primarily because they rescind multiple prior orders related to affirmative action efforts that need to be undertaken by federal contractors. So the most notable is the Executive Order 11246, which was signed into law by President Johnson in the 60s. So this, as originally drafted, related specifically to women and racial minorities, and President Obama extended it to include sexual orientation and gender identity. So that order required federal contractors to measure the demographics of their employees against the available workforce in the area, make efforts to diversify the applicant pool, and audit their pay practices, among many other requirements. And that is, like I said, rescinded at this point. I think it's interesting that the executive order does not apply to disability and veteran status. So it appears that federal contractors retain their affirmative action obligations with respect to applicants and employees with those characteristics. Contractors have until April 21st, 2025 to wind down their affirmative action plans, and they may comply until then, which I guess means if you can wrap it up sooner, you can. And then the order also imposes some new requirements on federal contractors. Specifically, it requires federal contractors to certify that they do not operate DEI programs violating anti-discrimination laws, and it makes compliance with this term a material part of the government's agreement to pay under the contract. And I assume that this is intended to allow the government to refuse to pay a federal contractor if they believe they're engaged in wrongful preferences, and or to allow individuals to file false claims or whistleblower actions asserting alleged violations of this order. So like employees could, arguably file a claim to try to enforce this. Finally, the order also indicates the Trump administration intends to make substantial efforts to end illegal DEI programs in the private sector. So within 120 days, the Attorney General is to provide a report with proposed strategies for enforcing civil rights laws and taking other steps to end illegal DEI. So the first part of this is the report is to identify key sectors of concern within each agency's jurisdiction. And I don't know if that means a particular industry or a particular kind of employee or what that might mean. The next thing is to identify the most egregious and discriminatory DEI practitioners in each sector of concern. So that would specifically be related to particular entities. The next thing is to identify a specific plan to deter DEI programs that constitute illegal discrimination or preferences. And this involves identification of up to 9 potential targets of civil compliance investigations. And this is particularly supposed to apply to large or prominent entities, like large publicly traded entities, large nonprofits, foundations, and institutions of higher education were specifically called out. And the report is also supposed to identify litigation or regulatory action that would assist in ending DEI programs for the private sector. So apparently whatever else they can think of to help do this. Okay, so I also wanted to make a note of the EEOC press release that was issued on January 28th, 2025. So Andrea Lucas was appointed acting EEOC chair by President Trump, and she issued a press release called Removing Gender Ideology and Restoring the EEOC's Role of Protecting Women in the Workplace. Never a short title. In the press release, Ms. Lucas stated, as per President Trump's executive order, the U.S. policy recognizes 2 sexes, and that the EEOC's priority will be to engage in litigation and issue guidance in accordance with this policy. She's particularly interested in ensuring women have single-sex spaces to work. The EEOC will be reviewing the Know Your Rights poster and considering revisions. There's not very much on that poster, so I'm not sure what they plan to do, but I suspect it would involve removal of notice of rights related to transgender or non-binary individuals. She also signaled her intention to remove or modify guidance which conflicts with the belief in binary sex, including but not limited to guidance related to harassment, which was explicitly mentioned in President Trump's order. However, I will note that several of these priorities require a quorum of commissioners, which does not currently exist after President Trump fired several commissioners. So because of that, we're not likely to see immediate changes to revoking old guidance or instituting new guidance, revising or implementing regulations, or changing EEO1 requirements. So we'll have to watch for changes there. Okay, next, I wanted to provide just kind of a few grounding reminders to think about before we talk about actions employers should take. And the first thing is that hiring and making employment decisions, including using preferences or quotas based on race or gender or any protected characteristic, has always been prohibited for private employers and contractors alike since Title VII. Notably, to me at least, the president's executive orders still recognize that discrimination against transgender, non-binary, and LGBTQ individuals is sex discrimination, despite indications that they want to roll back specific protections, particularly, like I mentioned, related to things like bathrooms. So what that means is the status quo has not changed that much despite the language around it. Okay, the other thing to keep in mind is that even conservative courts have consistently supported private employers' First Amendment rights to issue statements about diversity or inclusion and to require training in support of DEI with a few limits. So employers can speak about the value of diversity and inclusion, but should avoid any inference that diversity or protected characteristics would impact hiring. There actually have been a couple of lawsuits, based on a CEO's statements about how important diversity was. So there should never be any implication that that would change the hiring process. That's the limitation there. And then employers must be careful not to put any additional burdens on employees in the majority, but other than that, they can provide training on any topic they choose. So again, we're still kind of at status quo so far. And then finally, I just wanted to point out that based on the wording of the executive actions, which keep talking about illegal DEI, it's possible that that's code for a program which is simply a cover for identity-based hiring, as opposed to a DEI program that's really just informational. So obviously we can only speculate, but I find it hard to imagine that even the federal government can target every single DEI program in the nation. So as I said, I say this all to give you some comfort that employers are likely already in substantial compliance with the law, although there are certainly things and steps you should take. So with that, let's talk about what we should do to prepare. So the first thing you want to do is think about your organization's stance on diversity and inclusion going forward. And this could depend on whether you're a federal contractor, whether you're a large enough organization that you have resources to battle litigation or to deal with investigations. And also, I guess on the flip side, what is your mission? What's the organization do? And is DEI an integral part of it, such that it wouldn't make sense to really back down on that issue? So no matter what steps you take and what specific messaging you want to provide regarding DEI programs, you should reaffirm your commitment to compliance with anti-discrimination law. And you can do this in part by affirming that you value diversity in all dimensions, not just race, gender, sexual orientation, and so on. As a more practical matter, you will want to do an audit of every single, especially written material that you use, but also things like your hiring practices, to just determine, could this be considered a preference for an individual in a protected characteristic. So when we talk about preference, just to be clear, so if you're using a protected characteristic to give a candidate extra points or to use as a tiebreaker between two otherwise qualified candidates, that would be considered a preference that probably is illegal even under Title VII, and I would not encourage anyway, and certainly is the kind of thing you should make sure you're not doing anymore. Same thing with providing managers, for instance, with a tangible incentive for achieving diversity metrics. So this is a step removed from actually hiring based on protected characteristics, but it could create a motivation to improperly consider race, for example, and so I would want to avoid that. Training materials, you would want to take a look at those, but they should be acceptable if they're basically fact-driven discussions and neutral language focused on complying with federal anti-discrimination laws, and as long as they are uniformly required of all employees and don't imply that any particular group is likely to have bias or engage in wrongful acts. So as long as they're neutral, you should be fine. You also want to review your membership requirements and the purpose of affinity groups. You should typically allow affinity groups for all groups equally, so long as the purpose is a positive one. You should also, and this is a question I have gotten before in my practice. You should keep affinity groups open to all who are willing to join and participate in the mission, even if they are not a member of the protected protected group that is the mission of your affinity group. So finally, if after your review and your audit, you do decide to make changes, you may want to consult with legal counsel to make sure that when you communicate these changes to employees, you're not doing so in a way that implies you think you did something illegal in the past or engaged in wrongful conduct. And of course, you want to reassure your employees, and particularly your employees with protected characteristics, that you're going to continue to be fair to everybody, and you'll remind them of your resources and reporting options that they have available to them and encourage them to use them if they need to. Okay, so as far as what we should do to prepare in the future, you should start preparing for inquiries from federal agencies, and hopefully it won't happen. But if it does, you may want to have a team in place, which includes both internal folks and legal counsel, whether that's internal or external. You want to gather all your relevant revised policies that have anything to do with DEI and put them all in one place, along with any other information that might be helpful. For instance, demographic information could potentially be helpful to your point that you're not engaging in any improper preferences. You obviously, in connection with this, want to train your HR people and your company spokespeople and business leadership, anybody who might be interviewed, to avoid particularly risky messaging around DEI, which again, I would consider to be any message that diversity is valued above performance, or that diverse individuals are more valuable to the organization than individuals in the majority, whichever majority we're talking about. You want to prepare for reverse discrimination lawsuits. So these have been on the rise since Trump 1.0, and I would expect that to continue in light of these efforts against DEI programs. So the primary thing, in my opinion, that you can do to prepare for these suits is to take seriously any and all complaints that you get, not just from employees in the minority, but from employees in the majority. And you want to investigate any such complaint in exactly the same manner. You also want to maybe take an extra step to make sure that the accused employee is given a chance to provide, given ample opportunity to provide their story and any evidence in support of their story, so that you can't be accused of making any kind of assumption that wrongful conduct has occurred based on the identities of the individuals. And again, to the extent you don't already do so, be careful to keep records related to hiring and firing, promotion, demotion, and so on, as this is obviously your best defense when somebody may question the basis for your decisions. And again, we're going to keep an eye out for EEOC guidance related to transgender, non-binary, and non-gender conforming individuals, particularly with respect to bathrooms, which is really going to be an interesting issue to deal with. And of course, additional guidance and whatever they may issue on that subject and other subjects. And of course, just as a reminder for the federal contractors out there, you want to begin winding down your affirmative action programs. One question that we've already gotten is, what about federal contractors who also have state or municipal contracts? And the answer to that is, do your best, right? Try to separate out your obligations, keep track of your workforce data if you have to, and just, don't submit that to the federal government. And, to the fullest extent possible with respect to written documentation, try to harmonize your obligations. But it's just going to be a case-by-case thing. So with that, for the moment, I'm going to turn it over to Cleet.
Thank you, Casey. When I was watching President Trump enter the large number of executive orders on the inauguration day, I was acutely aware of anything that would impact immigration, and because of the significant level of bluster that we saw during the campaign concerning immigration enforcement. And essentially the executive orders that were entered with regard to immigration came down to two. There was a birthright citizenship executive order, which drew a lot of attention. And that birthright citizenship executive order was almost immediately found unconstitutional by several federal courts. It's been stayed, and it really has no impact on companies at this point. The second executive order was titled Protecting the American People Against Invasion. And it essentially just emphasized that the primary mission of ICE, or Immigration and Customs Enforcement, is to execute the immigration laws that had essentially not been executed with serious implication over the previous 4 years. That executive order um, uh, also noted that ICE would pursue those who, quote unquote, facilitate unauthorized presence in the United States through the use of civil fines and penalties and criminal prosecutions. So what that has told me, and what I've learned over the last 3 weeks being kind of out in the field and in the face of this increased immigration enforcement, is that there are several things that employers should be prepared for. And I'm going to focus on what I'm seeing currently and ways in which you can prepare for different levels of ICE enforcement at the work site. So next slide on that. The number one thing that we're seeing right now is an increase in ICE I-9 audits in the service of notice of inspections on employers. We're also seeing a return to what the media has referred to as ICE raids, which is really nothing more than worker arrests that are taking place on the work site. We've also seen priority memos that have been issued by ICE in which the restrictions on arrests made in sensitive locations have been removed. So now we're seeing arrests that are occurring at churches, schools, work sites, hospitals, courthouses, areas which were previously under the Biden administration termed to be sensitive locations where immigration and administrative arrests could not take place. We're also seeing a return of the Social Security no-match letters that are called employer correction letters. Essentially, we're seeing more joint enforcement between the Department of Labor, Social Security Administration, the Department of Justice, and ICE in identifying workers that are working on fraudulent documents, to include situations at companies where numerous people are using the same Social Security number, and it's being flagged by Social Security Administration, and we're seeing those. I'm sure several of you have worked through what to do during no match letter season, and we're going to talk a little bit about how to handle those. We're also seeing, and this will impact workforces, we're seeing a termination of temporary visa programs like temporary protected status. You may have seen Venezuela's TPS was recently terminated. I suspect the same will happen for Ukrainians and other, Afghanistan and Central American programs. Several of you have workers, that are working under those programs that have employment authorization documents that contain codes on them that show you that they're working in TPS status. I suspect the majority of TPS programs will be terminated over the next year. So, from a preparation standpoint, you'll want to really get in and review your I-9s to see what level of reliance your company has on TPS workers. With regard to DACA appears to be somewhat safe in the short term with regard to those individuals that have already been granted DACA. Renewals are still being allowed. There's several cases, federal lawsuits pending with regard to DACA. But again, those code 33s for those of you that really look at your EADs and want to understand how your workers have employment authorization, code 11s and code 33s, those are in relation to TPS and DACA. So that, if you look at those codes, you'll be able to gain a sense of what your potential vulnerability is for the loss of workers over the next several years, because many of these programs will be under attack. And then for those of you that rely on business immigration or employer-sponsored visa programs, I suspect those will come under attack. They have not yet to date, but the reliance on H-1B or other, employer-sponsored programs, H-2B, H-2As. Those programs are likely to be curtailed. And if they're not curtailed, you'll see a significant amount of regulatory investigation into your compliance with those programs. So, for example, H-2B compliant programs will probably start to receive site visits from the Department of Labor. They're responsible for investigating compliance with H-2Bs. So that's the expected immigration implications. I can tell you from firsthand experience that the first part of that bullet point list is well underway. And so the next slide will kind of show you here what we've seen over the last 3 weeks. You've probably heard the Trump-appointed border czar Tom Homan has indicated that large-scale raids would begin as early as January 21st. They did. We've seen on the day after the inauguration, there were 308 arrests that were made and publicized. A couple Sundays ago, there were reports that 1,200 arrests were made on January 26th. So these arrests are being, this isn't a Monday through Friday deal. This is a 7 days a week. And we're also expecting to see an increase in I-9 audits, according to Mr. Holman, of up to 12,000 per year. I've seen these particularly in the following industries: agriculture, food, hospitality, construction, landscaping should be on there, manufacturing, and we're also beginning to see them around critical infrastructure points. So if your company is located around federal buildings, in larger urban areas, we've seen those companies be targeted on the basis of critical infrastructure and national security. So that's being used as kind of a connector. If your company's located to a federal office building, for example, it would not surprise me if you get a notice of inspection within the next year, because we're seeing kind of those sweeps and the I-9 audit themselves are used by ICE to essentially look under your hood to see not only what your employment verification compliance is, but also what your workforce looks like. The I-9 audits typically come with an administrative subpoena that will include, various things like employee rosters, payroll reports, and things of that nature. So that the first stage in an I-9 audit is ICE gathering your I-9s and then running your workforce social security numbers and date of births against their own databases to determine the level of use of fraudulent documents to obtain employment. We can go to the next slide on that. So here's what we're seeing. I'm going to break it down into 3 different levels, and this is what you should be prepared for. So with regard to immigration enforcement, we're seeing essentially 3 different levels being used. Level 1 is probably the least invasive type of immigration enforcement at a company or at a work site. And that's the I-9 notice of inspection. You're given 3 business days to produce your I-9s, and then you're tagged with civil monetary penalties for knowing hired, knowing continued employment, and paperwork violations. So level 1, how do you prepare for level 1? Well, we're going to talk about it, but essentially you need to make sure your I-9s are in order, because we're seeing I-9 audits and notices of inspection served by ICE at very high levels right now. Again, I call that the look under the hood. That's a way for ICE to gather information about your company's workforce. If you're in those industries that I specifically highlighted, I think the likelihood you'll see a notice of inspection over the next 4 years is very high. Level 2 enforcement, and this is just my terminology. This doesn't necessarily come out of any executive order, but this just is my way to break down the potential implications, at your facilities. And The level two are specific ICE administrative arrests on site. So this is where ICE agents would, may visit your facility or your company to execute an administrative warrant. They're typically looking for an individual person or a group of persons that may work for you. These administrative arrest warrants do not allow ICE to enter into private premises or private spaces without consent. They're arrest warrants, and the individual that's sought in the arrest will either be taken into custody or issued some sort of a notice to appear in immigration court. These ICE visits, because there's increased funding and increased emphasis on the mission of identifying individuals who are in the United States without authorization, your business could be impacted by these isolated arrests, and it's likely to present itself through just a simple visit from ICE agents in your lobbies or at your front desk, potentially seeking information. I would just advise your companies to develop plans that on how they're going to deal with such visits, and then also to develop phone trees so that those types of visits can get escalated and handled by the right management teams within your companies. The third level that we see less of, because it takes a lot more enforcement work, is the level 3, which is a judicial warrant. This is your quote unquote raids. These are warrants that are issued by U.S. federal judges or magistrates. And these type warrants allow ICE to conduct searches, seize property beyond the public areas of your business. So this is the judicial warrant is essentially the result of several months of ICE collecting data and then applying for a warrant with a U.S. judge by establishing probable cause that there's criminal activity or other large-scale activities taking place at your companies. For the large majority of you, you do not need to worry about a level 3 ICE, execution of a judicial warrant. For those of you in particularly targeted industries like food, farming, and construction, this might be more of a realistic possibility for you. So you need to prepare accordingly. If we can go to the next. So, the main takeaways is if your company is served with a judicial warrant, you obviously want to review it carefully. You want to monitor the execution of the warrant, document any areas that are searched, items seized, individuals arrested. The main thing that you want to ensure with your employees and your front-facing employees, I would say, public-facing employees, do not obstruct or impede any searching or do anything that would potentially put you in the path of a criminal prosecution for obstruction of justice or anything like that. That's why it's important that you have plans, that you have guides, that you plan for these situations in the same way you would plan for, active shooter situations, tornado drills, or other highly potential disruptive occurrences at your business. And we can finish up here on the next slide, but the general takeaways are, what industry you're in, and your workforce, and your level of risk. And so your level of preparation should match your level of risk. And on the I-9 side, it's very important that you regularly train your personnel on the best practices. Because what will happen a lot of times is the same error on your I-9s will be committed over and over and over. And the current fine amounts range from essentially $500 to $2,700 per I-9 violation. So that regularly training of your personnel is key. Performing annual internal I-9 audits, correcting paperwork violations that you find before ICE gets there is key. And then obviously, retaining and engaging immigration counsel to assist with questions, unique questions related to I-9 issues and things is key so that you're not making that repetitive error and sitting on a potential large civil monetary penalty, because we've seen that to be a point of emphasis under the executive orders that were issued specific to immigration. So thank you. That's what I have on immigration, and happy to answer any questions with our remaining time.
Thank you. I know the implications of these executive orders are ever evolving, so really appreciate the latest updates on thoughts of, what might be to come in these dynamic situations. I know it's something we've all been watching closely, but great to hear from experts on what we should be doing. So appreciate it. I think we have some good questions in the Q&A from our listeners, so maybe we can hit some of those. And Casey, I think this first one is directed for you. While a lot of these laws and executive orders mainly affect federal agencies, employees, and contractors, what is the anticipated trickle down to private companies, and what adjustments should be ready to make? I know you hit a little bit on this, but I know it's a question that I've seen with a lot of my HR peers, so I think any additional context is helpful.
Sure. I think that the trickle-down effects for most employers that are not gigantic entities are probably going to be more in the reverse discrimination, probably an increase in complaints and an increase in charges, truthfully, because there's going to be confusion about exactly how to take these, orders. And so I think you may see an increase in complaints from employees in protected statuses. And you also, like I said, may see reverse discrimination claims. So unfortunately, I suspect what we may just see is a lot of activity until we kind of figure out what are the exact limits of these, the new policies, and to the extent the EEOC is willing to enforce the new guidance, which, or maybe I should say to the extent they are able is probably more accurate, because clearly they're willing. So, I mean, practically speaking, I truly think that you do want to look at your DEI policies and your practices around it more than ever, but I don't think you need to scrub out your EEOC statement or, your equal opportunity statement or anything like that. I don't think you need to remove protected characteristics. I think you just need to, be mindful of anything that smacks of a preference for employees in the majority. But the truth is, I don't see a lot of that in my day-to-day practice anyway. It's very rare where I ever come across an improper preference, which I would typically call out as a violation of Title VII anyway, because we're just not supposed to be making these decisions based on protected characteristics. So long story short, I think keep calm. I think you do want to do a review and make sure there's nothing that stands out as really dangerous. And that's probably something you should get counsel for, to help make that judgment. But after that, document, document, document. You can't be making any decisions without documentation to back up the reasons you're doing it, because I would expect to see an increase in complaints about everything. So that's probably the best advice I can give you at this point.
Appreciate that context, super helpful. And a couple of people were asking if this is going to be recorded and are they going to get the slides? Yes, we'll be sending that after. I know there's some great nuggets in the slides that people might want to refer back to. Casey, maybe one more question for you, and then we'll switch gears. Someone had asked, we had African American and Hispanic Americans who are worried about their employment and raising cases of racism in the workplace. How do we fight back on these policies and changes to stand with our diverse workforce who are genuinely afraid?
Yeah, I can understand that. I think it's a kind of a reiteration of the same thing. I think you need to rely on the language of Title VII. You need to rely on the fact that, as I said, even the executive orders acknowledge the existence and continued application of Title VII and all its protections, which include protections for all, individuals in those categories you're mentioning. I mean, and this may be small group, this may be one-on-one, discussions with people to affirm, that we stand by our policies and we support our people and we're not going to engage in anything unfair. And I think that other than that, I mean, all you can do is show by doing, and just make sure that you're thoroughly investigating and reassuring your people when they bring these complaints.
Yeah, helpful advice. I think always like referring back to your company values and the things that you stand on that are not changing is always helpful. switching gears to a question for Cleet, do you expect there to be issues or delays with employees who are going through the perm process or O1 visa applications or renewals?
I actually expect the opposite. I believe those highly specialized visas are going to become a priority. I think particularly the O1 visa, which is specific to individuals with extraordinary abilities and skills. I believe that on the business immigration side, um, we may actually see improvements on processing, and some of those backlogs will get moved out because there'll be less. There's more incentive. There's more incentive on the recruitment side to get those highly skilled individuals adjusted to lawful permanent residence so that they can open businesses here, permanently remain, and I do think that's probably going to be a positive of some of the other immigration focus.
We'll take one piece of good news and where we can find it. Um, I believe this one's also addressed to you. I wonder if any of these executive orders address whistleblower requirements, what we must do on top of any other state, federal laws to organize with federal grants.
There might be more cases, but if we're talking in the immigration side, we've always had, with regard to whistleblower retaliation or things of that nature, employees that turn companies in for unscrupulous or predatory practices. If that's what this question's intended for, I don't think that will be a real impact here. I think it's the same analysis. There'll be the same levels of whistleblower protection. I do think that ICE has opened the doors to a variety of different mechanisms for identifying unauthorized presence, and there's also a lot of misreporting out there. Like I've seen like reports about them offering a certain amount of money for every valid report of an unauthorized worker. There's things of that nature, but again, it would be the same analysis on whistleblower retaliation, but you could see an increase in reports being made on the immigration side.
Thanks. Casey, anything to add there?
I would say that I think that there was an intention to make it easier for whistleblowers to report federal contractors. That seemed to be the way the language in that one executive order was made. I suppose that would relate to if an individual thought that they were violating some, doing some kind of illegal DEI, whatever they may think that is. So, but that's the only thing in any executive order that I saw that specifically related to whistleblowing. I didn't see anything related to private entities.
Thanks. I think we have 1 minute left, so maybe one quick last question on, do you recommend businesses mentioned about immigration to carry out I-9 verifications now if they've been missed? Maybe a quick one.
Yeah, real quick on this. So USCIS has specific guidance regarding, like, if you do an internal I-9 audit, you discover that you're missing an I-9 for an employee. CIS recommends you immediately prepare that I-9 and do not backdate. Do not try to cover up the fact you didn't do it timely. Just complete it, get it done, and then attach a memo that says it was discovered during an internal audit. Never backdate. Backdating leads to prosecutions. Don't do it. And then secondly, with regard to E-Verify, E-Verify has a mechanism. If you discover cases that weren't created that should have been, E-Verify has a mechanisms for going back and creating a case for an employee you didn't E-Verify. Follow that protocol that's in your memorandum of understanding with E-Verify, and make sure you choose the right ground for why you did it. Don't choose an inapplicable ground for doing it. But that's my short response on that.
Thanks, like the practical advice there and tips. We're at time. Thank you so much, everyone, for spending time with us today. Thank you for the Kutak Rock team. This was so informative. I was definitely taking notes during the conversation. And for anyone, it's always a good idea to get in touch with your broker throughout these legislative changes, or your legal team to make sure you're staying on top of things as they're continually evolving, but really appreciate the time and keep an eye out for the recording and the slides. Thanks so much, team. Have a great afternoon.